Welcome, 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 everyone. Thank you so much for being here today. Welcome to a new day and a new title for Care Patrol. We're moving today from Tuesdays and Thursdays with Care Patrol to Mondays and Fridays under a new name, Care Concierge, which is not only what I hope you'll understand is our educational series and the title for that, and the offering, meaning that we really do want to tailor these courses to your needs and your specifications. And so with every evaluation that we do, that we ask of you, when you complete it, we ask a question, which is topics you may want to see. Now, not everyone answers, and you don't have to answer, but when you do, it helps us know that we're meeting the needs of the marketplace and of you who are out there working clinically to support other folks. And so anyway, that's part of the name, Care Concierge. It's also now the new name of our employees. We want them to think of themselves and be known as Care Concierge, and providing resources and options and information and knowledge, education to people. That's the goal we have at Care Patrol, and that's why we come to you today to do CEUs. Now, as you all may know who've been with us in the past, we are credentialed by the Alabama Board of Nursing and by the Alabama Board of Social Work examiners, and each of them credential us to provide you with a contact hour for this 55-minute course that we're about to teach. Now, a few things have to happen for us to consider this not only a contact hour, but a live contact hour. And what that is that we do a couple of things maybe differently than you might have ordinarily. So we do have an evaluation. I'll give you the link after we get started with this. It's Survey Monkey. Survey Monkey is a tool that we use, an evaluation tool that we use. And then in it, it's password protected. So about 40 to 50 minutes into today's presentation, we'll give out a password that will enable you to open that evaluation. And the reason we do it this way is to let the Board of Nursing and the Board of Social Work know that this is live, that you were here and I was here and we participated in this together, and we had a discussion if appropriate. This is why we do things, and this is how we do it. So we have an evaluation. I'll post the Survey Monkey up into the screen. As we don't have a PowerPoint today, I'll put it in the chat room. If you don't know how to open the chat room, just hover over the bottom or top of your screen, and you should see a box appear with the chat, and you can click on that. So please use the chat room. And today, unlike many times, we are also allowing you to unmic. So we're having a discussion today with Pam Strickland and Bill Nolan. They were with us about, I guess, 3 months ago. We talked about Medicaid with Bill and Pam, and today we will refresh our memories on that, talk about what we talked about at that time, and then get a little bit deeper into Medicaid. And I think you're going to hear and learn some surprising things, just one of which is a teaser, is when to apply for Medicaid. That's a very complex question, and Bill and Pam will discuss that as well as other things today. And so we appreciate them being with us. So as I said, I will be posting the Survey Monkey link into the chat room. I'll be posting the password about 50 minutes into this presentation. You have the option to unmic and ask questions if you like, or you can post them in the chat room. This is 1 hour credentialed by the Board of Social Work and the Board of Nursing. And we are changing our name from Care Concierge with Care Patrol. It's Monday. We'll be with you again on Friday, when we'll discuss caregiver stress syndrome and caregiving strategies for stress-free relief. And then today I'm gonna sit back, relax, and do probably very little as Bill and Pam take over and begin discussing with us more about Medicaid. So y'all welcome them, make them feel welcome, and please do participate and ask questions. Thank you, Bill. Thank you, Pam.
You bet. Thank you, Sean. Well, good morning or afternoon, everybody. Last time when we talked about Medicaid, we discussed the basic qualifications for eligibility, what you have to do simply to qualify for the benefit. We also talked about what the benefit means in terms of dollars and so on for those that were approved. Today, though, much of our conversation is going to revolve around when is the right time to apply for Medicaid. And you might say, well, heck, the answer is obvious. It's when you need it, it's when you apply for it. Well, I wish it were that easy. A typical scenario, older married couple. Let's say the husband's health is declining and the wife is the one taking care of him. The wife is called the community spouse. She's the one who stays in the community. The husband who's going into some sort of a facility is called the institutional spouse, CS and IS. In many cases, when a person's health is declining, as y'all know, it's not like 1 minute I'm completely healthy and 1 minute I'm completely disabled. It's usually something happens, caregivers come into the home for a while, and then maybe the person has to move to assisted living for a while, and then maybe they have to transition up to memory care for a while. And then at some point, the memory care facility says, we can't handle him any longer. He needs to go to skilled care. Well, Medicaid is only available once you reach the skilled care level. So the community spouse, the wife, has been paying every month for assisted living or caregivers and assisted living and memory care, and she continues to pay for skilled care. They have the money in the bank. Let's say they have, $300,000 or $400,000 between them, and she just continues to privately pay. More often than not, she continues to privately pay until the money runs out. And the question is, well, why would she do that? Why would somebody, if there's another option out there, if there's an alternative, why would you continue to write checks for $9,000 a month if you have another option? One is pride. Oftentimes pride keeps people from considering Medicaid as an option because they think it's only for poor people, or they think it's only for people who are somehow deficient in some character quality that they certainly have no deficiency in. Or maybe the Medicaid agency's page clearly says you can apply for Medicaid when your assets reach the point of $2,000. Or maybe she's failed to consult with an elder care attorney about what her options might be. So the question is there an ideal time to submit a Medicaid application? Pam is with us today. Excuse me. And Pam owns a company called Medicaid Application Processing Services. And she's been doing Medicaid applications as a paralegal and then as a private business owner for years now. And she's probably done more Medicaid applications in Alabama than anybody else. In fact, her success rate up until fairly recently was 100%. I sent her a referral who was a dishonest person who misled both of us, and it caused one of her applications to be denied. So, but for my referral, she would still be at 100% success rate. And it's my fault and I accept the blame. So Pam, in your opinion, having done hundreds of Medicaid applications over the years, is there, in this couple, it's married couple scenario, is there an ideal time for them to consider submitting a Medicaid application?
Yes, but let me say this, Bill, and I haven't spoken with you since last week, but that Medicaid application was approved on Friday.
Oh, great, great.
Because we got DHR involved along with the DA for certain county. And the person who was dishonest is being handled through DHR and DA.
Excellent.
And we worked with Medicaid, and that woman is now approved.
Excellent.
So,
thanks for the update. Appreciate it.
Just let you know that came in to me on Friday. So
okay, great.
yes. Now to get back on your question, yeah, there is an ideal time, and that is when we look at the assets of a couple, and we want the community spouse to be able to keep 50% of the couple's total assets. Now, under most that a couple can have to apply with Medicaid is $274,800. And that's as of 2022. And she would get to keep personally one half of that, which is the $137,400. So if she's trying to spend down to below 2,000, she would be spending much more than that. So what we can do is take the 50% of the assets that the husband or the institutional spouse has after we split it, and we can take those assets and we can place those into the Alabama Family Trust here in Birmingham, and that would get the couple or the institutional spouse Medicaid qualified the first day of the next month. Now, that means that she gets to keep one half, 50% of the assets. This is not counting the home. They can have a home, and it could be a 50% ownership in the home. They can each have 50% of that. And the difference there is that his 50%, Medicaid would put a lien against. So upon the death of the institutionalized spouse, Medicaid would, at the time the house is sold, whenever that may be, would then take 50% of the sales proceeds. That is if the money in the Alabama Family Trust does not cover the amount that Medicaid paid on behalf of the institutionalized spouse. We know that, let's say they have 137.4 in there. Medicaid pays 5 months or 4 months on their behalf. And we know that Medicaid has a negotiated rate with nursing homes that is below the rate that a private pay individual has. So that would save them money. Now, Bill, you mentioned that $9,000 per month for a nursing home. So if we do the math with that, and I think you may have notes on that, Bill, but if you do the math on that, they could save quite a bit of money letting Medicaid pay those months, and Medicaid would then take the money from the Alabama Family Trust, as opposed to private paying at $9,000 a month.
Let me jump in here. I want to practice my active listening skills.
Okay.
They say you repeat back what you've heard. Just so I want to practice my active listening skills.
Okay.
The first point was that yes, there is an ideal time for a couple to consider filing a Medicaid application, and that is when their total assets, not including their home, were around $275,000, because the community spouse gets to keep half of that.
That's correct.
And there's no reason why she should wait until they've spent all of their money for his private paid nursing home care, because she's spending her money, not his money. So I think the point here is apply sooner rather than later. Most couples don't even consider Medicaid as an option until they're dead broke. And by then, the community spouse has wasted resources that she could rely on for the rest of her life. The other point you make is that if you apply sooner rather than later, if you're privately paying for a nursing home bed, you're paying $9,000 a month, maybe $10,000 a month. And that's every month, check after check, and you don't know when it's going to stop. But if Medicaid is paying for that nursing home bed, they have a negotiated rate, and it may be $6,600. That's what the average monthly cost of care is. Well, over time, the difference between $9,000, what you pay, and what Medicaid pays of $6,600, that adds up. And if you're in a nursing home for 3 years, you could save maybe $100,000 by letting Medicaid pay the bill versus you paying the bill. So yes, there is another reason to apply sooner rather than later. Not only can the community spouse keep a large chunk of their assets, but she can get a wholesale rate on a nursing home bed. Why wouldn't she consider that? So far, so good. Did I summarize that fairly?
You did.
Okay, good deal. Now, you also mentioned the Alabama Family Trust, and I guess the point there is, we know that the community spouse can keep her $137,400. What does Medicaid say has to happen to the institutional spouse's one half, or his $137,400?
It must be spent down to $2,000 or below, or placed in a vehicle in an Alabama, that's the Alabama Family Trust, which is a Medicaid payback trust. That means that this 137.4 is placed in the Alabama Family Trust, and that money can be used by the community spouse to enhance the life of the institutionalized spouse during the time they're on Medicaid.
Like a private room, for example.
That's
Medicaid
right.
pay for a private room, but you could use that money to upgrade to a private room every month.
That's correct. It also pays things like cable bills, pays for private electronics, cell phone bill. You could purchase pajamas and clothing for them while they're in there using the Alabama Family Trust funds. You could
let's say that this community spouse wants to go out of town, wants to take her grandkids to Disney World for the week, but she feels guilty because her spouse is in the nursing home. Could she use the family trust money to pay caregivers to take care of him while she's out of town?
She can, but it's very specific how the Alabama Family Trust works for that. The caregivers must be caregivers from a company that has an EIN number, and they must get a 1099.
So like Sean's business, or not Sean's business, but some of the caregivers in Sean's network here most likely work for companies where they're paid a paycheck, and they would qualify. Yeah.
Yes, that's correct. And someone just asked, could there be sitters? If those sitters are paid through a company under the same, it has the 1099 that gives them the 1099, then yes. But if it's a family sitter that you pay $10 of cash to, and you're going to pay that from the Alabama Family Trust, you're just going to pay them cash, no, cannot use those.
Yeah, right. It has to be a legitimate caregiving company.
That's correct.
But that's correct. But if the money's not in the family trust, if you don't have a family trust set up, well, it either comes out of the spouse's pocket or it doesn't get paid at all, does it?
That's correct.
So it's a huge benefit for the community spouse because it buys her some freedom, I think. So we know that many couples will wait until the last minute to apply for Medicaid, which is a bad idea. Yes. And I don't know why people do it. Well, I do know one reason. And it probably has nothing to do with the people who are on this call today who work in the skilled care industry. But there's some people out there who give advice to the folks who are in the skilled care facility about the application process. Would you care to elaborate on that, Pam?
I have a lot of clients who come in to meet with me who've been told that they won't qualify because they're over qualified, or that there are things that have happened in their past 60 months that will preclude them from being qualified for Medicaid. And there are always bumps in the road, but no, there can be qualification for Medicaid. And normally, once we walk through the process, we see exactly what happened. Many times we can cure those defaults. And then other times we utilize the Alabama Family Trust. And there are also other ways, you've got the Alabama Family Trust, but you also have Medicaid compliant annuities. And that's something that Bill can speak to you about, being an elder law attorney. And let me just say this too. When an elder couple goes to their attorney and they have their estate plan done, it's great. I mean, they need to do that. But as they get older, they must realize that the importance is not just an estate plan, but it's in a plan that is looked over and drawn up by an elder law attorney who understands the nuances of Medicaid and what is needed to make sure that the qualifications for Medicaid are met. So I tell people it's not good enough to have an estate planning attorney. You need an elder law attorney who understands these things so that if you have a 5-year plan, that plan meets Medicaid requirements. And those are things that are specific to elder law attorneys like Bill Nolan. Well, so I always refer those to Bill because I want him to set them up in a way that's Medicaid compliant.
Well, thanks for that plug. I appreciate that. Truly, one of the situations we see a lot, and I'm sure you've seen it as well, Pam, is an older couple will have mutual wills, and those wills say, if I die first, you get everything, and if you die first, I get everything. Those are, we call those I love you wills in the industry. Well, let's say then that the community spouse in our scenario, the wife, has kept her $137,500 in her name. And let's say that she's done some deed work to also protect the home, which is something we hadn't talked about yet, but you could do. So now the house is just in her name. So her $137,000 and the house is in her name, and husband is now qualified for Medicaid. And she dies first. Well, her will clearly says, if I go first, you get everything. So all this work she's done is for naught. It flows back to the Medicaid recipient, and Medicaid has dibs on it, which means now Medicaid has become the prime beneficiary of your estate, which is not what anybody would want. So one of the discussions we have when we're talking to a couple about qualifying for Medicaid is, community spouse, you need to update your estate planning so that you, unfortunately, have to disinherit your spouse who's in the nursing home, or else Medicaid's going to get it. And the reality is, if he's in the nursing home, he can't be her executor. He can't be the agent under her power of attorney. He can't be her healthcare proxy. So there's no reason to leave it the way it is. But if you don't update it, it's going to cost a lot of money that your kids might otherwise get. So yes, update. And also on the power of attorney topic, one of the weaknesses in our system, I think, is that when a typical person sees a document that says power of attorney across it, they think they're covered. I've got a power of attorney. It says so clearly right here on page 1. Well, powers of attorney vary in terms of what they do, how comprehensive they are, when they go into effect, and what the client doesn't know is that in order for someone to qualify for Medicaid, and especially to qualify for the Alabama Family Trust to protect your assets from Medicaid, your power of attorney has to have certain magic language in it that the vast majority of estate planning attorneys don't include. They don't know it. They just don't realize that that's an issue, but it is. And it can create major problems once the wife is trying to, or the children are trying to get a Medicaid application for their parent, because they don't have that magic language in there. They didn't know that it's missing because their lawyer didn't know that it was missing. So that's another reason why elder law attorneys are fairly critical at this stage in the life of a person, because we do know that. We can include that. And if you start the Medicaid application process earlier rather than at the last minute, the person in the nursing home may still have some semblance of capacity and may still be able to sign a new power of attorney. But if you wait until the last minute, of course, now their capacity is so far down the line, they can't possibly sign one. Pam, on the topic of, we mentioned the house just a minute ago, but on the topic of the house, you know, the house is sometimes the largest asset that people have. And is there a way that a married couple can protect all or a portion of their house from Medicaid getting it? That's a fear that everybody has. I don't want Medicaid to get, or I don't want the nursing home to get the house.
Right.
When in fact, it's really Medicaid who's going to get the house. The nursing home doesn't want the house. They just want to get paid. So is there a way that people can protect their homes?
Yes. Married couples can take the house and quit claim their portion one to the other. And that is completely fine with Medicaid. So that means if the institutionalized spouse is the husband, he can quit claim his 50% portion of that to the wife, the community spouse. Now she has 100% ownership in the home. And now you cannot quit claim 50% to a child or to a caregiver. That does not work. It must be spouse to spouse.
Yeah, that's one of those things that people don't realize is the rules say you can't transfer any asset for less than fair market value to anyone within 5 years of applying for benefits, but it allows transfers to the spouse with day before Medicaid. You can transfer assets to the spouse. Okay, throw that in.
Yeah, that's true. And I have a lot that come to me children who say, well, what we thought we'd do is just transfer the house to us, let mom live in it. And I'm like, no, can't do that. There are different types of deeds you can do, certainly. But you would definitely need to see an elder law attorney for that. But fair market value must be paid for purchase of the home to anyone besides spouse to spouse.
So the institutional spouse, the husband in our scenario, could sign a deed conveying his interest in the house back to his wife. And now he doesn't own a house, so Medicaid doesn't have a claim to the house.
That's correct.
Medicaid would go ahead and file a lien, though, because what if the community spouse dies first? It may flow back to the institutional spouse. So they'll file a lien, but the most they could expect to get would be possibly up to his 50% interest in the house, if there was a 50% interest.
That's correct. That would be the most, and that would happen at the sale of the home.
So the community spouse could live in the house for years, decades after he died, and Medicaid wouldn't have a claim, couldn't run her out, couldn't make her leave.
No.
And then when she died, the house would pass through her estate to whoever she named, but Medicaid would then have an opportunity to cash in on their lien. Is that it?
Yes. Yes, that's correct.
So the short answer is yes, you can protect all or at least a portion of the house from Medicaid in a married couple scenario, if you do explore how to deed the property back to the spouse. Now, I guess the weakness in that would be if you conveyed the house from the institutional spouse to the community spouse, so the husband could get his benefits, and then a couple of years later, the wife has to go into the nursing home too. Well, what do you do then? You really hadn't protected it, but that you tried. I guess that's part of what this is trying your best to protect everything and knowing that facts and circumstances do change down the road.
We have a question, which is, can you quit claim property that still has a mortgage on it?
Sure, you can deed property. The ownership of the property is controlled by the deed. The liability on the mortgage is controlled by the note. So you can convey property out of the original grantor's name, but you can't transfer the liability. You're still on the hook for the liability, even if you've transferred the property. So if, let's say that you have a house and you have a mortgage on it and you conveyed the house to your kids, you're still on the hook for the loan. And at your death, the note, the obligation doesn't go away. It's still on that property. And your death is what they call an event of default on the mortgage. There's a provision called a due on sale clause in all notes like that. And it would come due. And they would write your kids and say, you're living in our house and you've got 30 days to get out or we're going to have you kicked out. So yeah, you can convey property, but you can't ever get out from under the mortgage other than paying it. We had mentioned what happens to the institutionalized spouse's share of their his $137,400. The wife gets to keep hers free and clear. Nobody says anything about that. But the husband, he has to spend his down to $2,000. And some facilities might say, well, you just privately pay your nursing home care until you're down to $2,000. And that's certainly one way to do it. But a better way to do it would be to put all of the money, or at least a portion of the money, in the Alabama Family Trust. Because yes, at your death, whatever's left is Medicaid's, but until then, the spouse is in charge of it. You can pay for caregivers, you can pay for private room, you can pay for subscriptions, you can pay for clothing and all that stuff. If a person, though, has an IRA, that's different. An IRA is what they call a qualified plan, which means the money went in pre-tax and you don't pay tax on it until you pull it out. And many people, when they hit age 72, they have to start taking what they call minimum required distributions, so the IRS gets their tax revenue. Well, Alabama Medicaid agency doesn't see an IRA as any different than a savings account. So if you apply for Medicaid and you have a $100,000 IRA, Medicaid's going to say, you're going to have to cash that in and you're going to have to spend it before you're eligible for Medicaid. Well, that hurts because not only do you have to pay a big chunk of tax, maybe $30,000 in tax, but now that money is no longer available for your spouse to rely on. So what can you do with an IRA? Well, there's something called a Medicaid compliant annuity. I don't expect y'all to remember all this other than to know that it's an option. But Medicaid has, if you remember back when we talked about this a couple of months ago, Medicaid says you can have up to $2,000 in assets, and we only consider the institutional spouse's income on the application. So in our scenario, the wife, her income doesn't matter. She can make $10,000 a month, and it's not going to affect her husband's Medicaid application. So let's say the wife has a $100,000 IRA. Well, that's an asset the couple own, and Medicaid's going to say, you got to withdraw it, pay the tax and spend it, or use it to as part of the community spouse resource allowance calculation. But if the wife takes that IRA, which is an asset, and converts it to an income stream that's payable to her, it's off the books. So what she does is she converts her IRA, $100,000 asset, into a Medicaid compliant annuity, which pays her for the rest of her life. It doesn't count in the calculation for eligibility at all. Her income goes up however much that is. So she has even more money to live on than she had before, and her husband can qualify. So just understand that there's something called a Medicaid compliant annuity that's there to help a couple manage IRA and 401k, 403b type assets to their benefit. Is that about right, Pam?
That is, and let me just say this. Let's start a conversation here about, we've talked about the couple's assets, but we need to look at something specific, and that is, at what date does Medicaid look at the total assets for a couple? And this date is called the snapshot date. Okay, so this date is one of three things. It is the date that the individual was institutionalized, whether it be in the hospital first, then to rehab, and then to the nursing home, or it is the date that the institutionalized spouse went to the nursing home and was admitted, or to rehab and then to the nursing home is admitted. Medicaid looks at that date as a snapshot of all the assets. So let's say that they were in the hospital, and then they went to rehab, and then they moved to the nursing home. They could have been 3 weeks out. They could have been in the hospital for 10 days, rehab for 10 days, and then moved over to the nursing home. So they look at the snapshot date, and it may be 3 weeks prior, and they take that amount of money, and that's the amount of money they work with. Well, people say, well, we spent money since then. We've had to pay for his rehab, or insurance ran out. We're paying a per diem or whatever. Makes no difference. The date of the snapshot, and it does not move, is the date they were institutionalized, the first day that they didn't go home. They stayed institutionalized until they went into the nursing home. That is the snapshot date. They take that amount of money on that date. That means that if you have an IRA, you get the amount of that IRA on the date of the snapshot date. Your savings account, you need the balance, the date of the snapshot date. Same thing with checking accounts, CDs, all of it must be a balance, the date of the snapshot date. And that's the date, that's the amount they go with. That's the amount you must spend down or divide and put into the Alabama Family Trust. So I just wanted to be
all your money, if over the snapshot date was a year back, and since then you've spent down virtually all of the money on private pay or whatever, and it's not available for the community spouse, she's just not going to get it.
That's right.
Yeah,
that is correct.
So another reason to apply sooner rather than later.
That's correct.
We had a question pop up I saw at the bottom about irrevocable trust, and is that still a good planning tool? And the answer is yes, depending on the circumstances. To transfer assets into an irrevocable trust, they have to be transferred for at least 60 months, 5 years, before they are considered no longer an asset by Medicaid. Many people, they plan not far enough in advance, and they might have 2 months before they have to apply for Medicaid. They don't have the luxury of transferring an asset and waiting 5 years. So that's something we're always preaching is this is like buying property and casualty insurance. You don't wait until the tree's laying across your house to try to buy the insurance. It's too late then. Buy it now and hope that it doesn't storm. It might, and if it does, you're going to be glad you had the insurance. And that's the same way with irrevocable trust. You have to convey assets 5 years or more out for them to work. And another question that popped up was about the Medicaid compliant annuity. And you're right. For years, we went to seminars and heard about how Medicaid compliant annuities were working in other states. And Alabama was they said, nope, we don't accept them. Now I've heard, though, that they are accepting in Alabama. They're acceptable if they meet certain requirements. One is has to be Medicaid compliant, meaning it can't exceed the life expectancy of the Medicaid person, of the person who owns the annuity or the Medicaid applicant. So if the person has 15 years of life, it can't go out 20 or 25 or 30 years. It has to be life certain. The second is it can't be something they could sell. I don't know if you've noticed these J.G. Wentworth ads on television where they say, we buy annuities, So you have a $100,000 annuity and they'll offer you $25,000 for it. Well, some people would jump at that chance. Well, the annuities, in order for Medicaid to accept them, cannot be something that could be sold or transferred to somebody else. Yes, according to Kraus Financial Services, a national company that provides these Medicaid compliant annuities, they are acceptable in Alabama now. So you can't list beneficiaries for the annuity. You can, but Medicaid has to be the primary beneficiary on a Medicaid compliant annuity. So let's say that you use your IRA and your spouse is in nursing home. Well, it's your property. It's your IRA is your property. So you annuitize it. During your lifetime, you receive all of the income stream on it. And at your death, if Medicaid is owed anything, because it maybe, I don't know how it exactly would work there. If you owe Medicaid anything, Medicaid would have a claim to it. Now, if it's your annuity and you're receiving the income, I don't see how Medicaid is going to have a claim to any of the income because you're not the Medicaid applicant. You're not the Medicaid recipient. In that case, it would pass to your kids or grandkids or whoever you wanted.
We have another question, which is, how does the snapshot work in regards to the 5-year look back in terms of asset calculation?
Well, we must remember that if the couple, if the individual has been in the nursing home for quite some time and you've been private paying, and then you want to apply for Medicaid at that point, you don't have to worry about the snapshot date because you're private paying and you're paying down your own assets. And, the snapshot, even though you may have a snapshot date, you paid down so much by that time, it's not something that they will look at. They look at your assets at that time that you apply. But let's say that you're recently in the nursing home within the past 90 days. That's when the snapshot date becomes very, very important because that's when they pull that snapshot date amount. I have seen them pull a snapshot date back a year, but I've never had one pulled back more than that.
And another question, 2 more questions. One is, when should the community spouse get the Medicaid applicant annuity? And the other one is, if y'all could maybe type in the chat room how to refer to you each. We've had someone ask.
The Medicaid compliant annuity can be applied for, and your IRA would be converted to this Medicaid compliant annuity at any point prior to the Medicaid application going in. And it takes, Pam can tell you exactly how long it takes, but anywhere from a month to 2 months for people to pull together all the information they need to set up a Medicaid application. You have to get bank records and property records and fill out the application itself, maybe set up a family trust. So you've got plenty of time to do that. It just has to be done before you submit that Medicaid application.
And sometimes it takes the company 30 days to even get that set up. So we usually say try to start as soon as possible. But if you're going to be doing that, that means that we would not file until that is taken care of. So normally 30 to 60 days.
Okay.
And those are the questions. I'm putting in your contact information. So
Oh,
y'all,
yes. Thanks.
Thank you.
You know how to do
continue
it better than I
to,
do. So thanks. So I think what we've sort of learned from all of this, I know it's confusing. It took me literally years to get a handle on all this. So if you're confused, you're in good company. But what we've learned, I think, is that when there's a married couple involved, there are certain real significant dollar benefits that the couple can see if they apply for Medicaid at the front end, rather than waiting until they're almost dead broke and desperate to apply. One, of course, was you're getting the wholesale rate on the nursing home bed, which before you were paying retail, and that could be a couple of $1,000s a month right there. The second is the community spouse can protect what is her fair share of their life savings, the community spouse resource allowance. She can protect $137,000 if she applies sooner rather than later. She can also create the Alabama Family Trust so that private rooms paid for, caregivers are paid for, and all that. Whereas if she waits until they're dead broke, she gets a semi-private room. She doesn't get caregivers. She gets whatever pajamas they happen to give him at the facility and so on. So there's some real significant benefits to apply sooner rather than later. In your talks with folks and your family, you'll see that people don't want to apply for Medicaid for whatever reason until the last minute, and that's just bad thinking. You really need to think about this as a real benefit. It's a benefit that you've been paying for from your very first paycheck on, whether you think about it or not. And you might as well take advantage of it if you need it, because that's what it's there for. Did we leave anything out of all that, Pam? I'm trying.
Well, I'd like to talk for just a minute. One of the misconceptions that we have, and Bill can attest to this, is that I have couples come to me, the spouse, and say, I won't have enough to live on if my spouse is in a nursing home and Medicaid takes everything. And I want to clear something up. There's something called a MIMNA, and what that means is the minimum monthly needs allowance that a spouse has. And Medicaid does not allow the community spouse to fall below certain criteria as far as monthly income. Normally it's the female or the wife that has this problem. The husband has been the worker and he's earned so much more. So his Social Security is much higher than that of the spouse. So the amount that Medicaid says that the spouse cannot fall below for monthly income is $2,888.75 for 2022. That means that, let's say that her income from Social Security is $1,000 a month, and that's all she gets. She doesn't have retirement or anything else. She gets that $1,000. Medicaid will allow her to take up to the difference to get her up to the $2,288.75 per month for the spousal income, and the remainder of that will go to the nursing home. So I just wanted to make sure that people knew. Now, if she makes more than that, if she does have an annuity that pays her, and she's got retirement, if she makes that or above, she can't take any more from the husband. But if she has below that, Medicaid wants her up to that plateau, and that goes up each year, and they'll bump her up, and that comes from the Social Security check.
Now, that's an important benefit that people don't think about is that you can shift the income from the higher wage earner to the lower wage earner to help supplement her monthly needs. So we talked about the community spouse resource allowance. Resources are assets. The minimum monthly needs allowance is income. Both of those are available to the spouse who stays at home. And the minimum monthly needs allowance is I guess one of those things that people just don't think about. We also talked about the Alabama Family Trust as a way to protect resources, excess resources, so you can qualify sooner. There's also another kind of trust called a qualified income trust. They're called QITs. They're basically glorified bank accounts. And they are designed to protect a person's income if their income exceeds what Medicaid says is allowable. Medicaid says that you can have, what is it, 20, it was 25, 23, now it's 28 something a month. If you make a dollar over what Medicaid says is the income cap in Alabama, technically you're not eligible.
Mm-hmm.
Well, a lot of people have more than that income, so they can put the excess income into this qualified income trust, qualify for Medicaid, and the money in that trust can also be used to supplement their needs during their lifetime. Anything left over goes to Medicaid, but meanwhile, you're getting your room at the wholesale rate, not the retail rate.
True. And one thing I'd like
question. Sorry, we have another question. If the institutional spouse dies, then the community spouse gets his Social Security amount and any pension that would go to a spouse.
Well, yeah, if it's a true pension, like an income stream, not an asset, but an income stream during the institutionalized spouse's lifetime, that would be part of his income calculation. But if there was a spousal remainder benefit, then it would pass to her. Medicaid wouldn't have a claim on that because it's income after his death.
Mm-hmm.
At least that's my understanding, unless Pam.
Yes, I agree with you. I agree with you. And one thing I wanted to say, as far as the QIT, it's something that I have to correct quite often when people come to me. If the institutionalized spouse was a veteran and they have the aid and attendance benefits paid to them, a lot of times they're told by certain facilities that they need to open a QIT because their income is above what Medicaid allows. That simply is not true. Medicaid does not look at the aid and attendance pension, because that's going to be reduced to $90 per month once Medicaid is approved. And if that drops in below that QIT amount, there's no need to open it and then close it right after it drops down. And so Medicaid just does not look at that part of it. If they are still above the amount for QIT after it drops to $90, which is to be held by the individual, it doesn't go to Medicaid. They get to keep $90 per month as a personal needs allowance and $30 from Social Security. So that's $120 a month they get to keep. And I tell my clients, take it out of the bank, put it in an envelope, and spend it as your institutionalized spouse needs. But just to let you know that you do not have to open a QIT if the reason why you're over the income limit is because of aid and attendance benefits from the VA.
That comes up quite a bit. If a person is a veteran and has applied for Medicaid, they must submit a VA application, even if they're not going to be eligible. They were dishonorably discharged, or they served during peacetime, or for whatever reason. Mm-hmm. Medicaid still expects them to file that application. Mm-hmm. So I guess in wrapping up all this, as we're closing in on the end of our time together, from the lawyer's perspective, and somebody said, can you refer people to us? Of course, yes, absolutely, anytime.
Please
do. We would sit down with the community spouse and discuss the need to maybe modify her estate planning so that she's not naming Medicaid as a beneficiary. We would talk about the qualified income trust after looking at their respective incomes, talk about the community spouse resource allowance when we looked at their assets. We would suggest that they should think about possibly improving their power of attorney. If it's one of those powers of attorney that's a half a page long document that doesn't really give them anything in terms of magic language. And then we would refer them to Pam to talk about the Medicaid application itself, because that's something that needs to get started sooner rather than later.
All right. Well, thank you so much, Pam and Bill. We've still got 10 minutes, folks, on the call. If you have any questions, now's your time. You get free time from an attorney. Now imagine that. It doesn't happen all that often in life.
No, it doesn't. It doesn't.
So if y'all have any questions, please ask them now. I have put into a couple of times into the chat room the Survey Monkey address and the password. The password is snapshot. Cassandra wants to know, how much do you cost, Bill, or an
That's a
elder
great
law attorney
question.
cost in general?
You know, what we found is that the typical couple, 80-year-old couple, let's say, they've been married for 60 years to the same spouse. They've lived in the same house for 60 years. They have stayed out of trouble. You know, they haven't gotten DUIs and haven't gotten arrested for disorderly conduct or whatever. So they haven't met a real estate lawyer. They haven't met a divorce lawyer. They haven't met a criminal defense lawyer. They don't really know any lawyers. And their whole attitude about lawyers is framed by Boston Legal or CSI or one of these shows on television. And there's maybe some stereotypes they have about meeting with lawyers and what's involved. And the reality is those lawyer shows are just about as accurate as the hospital shows are. You know, in other words, they're not accurate. But that's not what people think, especially when they're 80. So we try to keep the threshold as low as possible. We don't charge to meet with people to talk about their situation. We want to be able to talk to people without them having to write a check. And if there's work to be done, we'll give them a fixed fee quote as to what that work will cost. They can walk out the door, and if we never see them again, it hasn't cost them a dime. But that's the way we do it. It seems to work. So
now I agree. I do the same thing. I meet with people quite often, and we charge by the complexity of the case. And so people come in and meet with us. We give them information. We talk with them. Usually takes about an hour, and then they can leave. And we welcome them to call us back and retain us. But I want them to know that when they come to us, that we're here to take the stress off of them, and that includes answering questions however they need it. And we don't charge for those consults.
There was a question about personal property, cars, jewelry, and other assets. You know, tangible personal property is what we call that in the trade. Stuff, you know, your toys, your furniture, furnishings, coffee maker, sofa, televisions, all that stuff. Medicaid really doesn't have a strict rule about that. I mean, they're not going to come in and do an audit of your stuff. Now, a car, they'll let you have a car. But you can't have 2 cars, you can't have 3 cars, you can't have 4 cars, you can have 1 car. And I guess the idea there is people need a way to get to and from the doctor's office and to and from the hospital. And so they allow you to have a car, but that's about it. Everything else, you know, jewelry. I mean, if you had a Rolex collection, you know, I don't know. Is there a place on the application, Pam, for a Rolex? There is, okay. So
but not specifically Rolex, but it says, do you have any collectibles or antiques? Mm-hmm. And I'll be honest with you, I tell people, you don't. Because they will make you sell them and give them the money.
I see. So the Beanie Babies don't count as a collection with
They do, but I tell people, if you're going into a nursing home, you don't need your collection of Beanie Babies. You're going to need to just get rid of those. Yeah. You know, you can do an estate sale, keep track of everything, put that in an account, and then we can put that in the Alabama Family Trust with everything else. Mm-hmm. But you don't want to give those to Medicaid. Mm-hmm.
Well, of course, you know, the Medicaid application is my understanding is it's a sworn application. You're supposed to tell the truth on it. Yes. And if you don't, I suppose you're guilty of perjury or, you know, something else.
That's right.
But then again, you know, some people might not see the value in the Wedgwood that other people might. So there's some wiggle room, some gray area there, I suppose.
Yeah, and that's why I like estate sales. I tell people, look, if you've got these things, you know, we're not going to lie on the application. You need to go ahead and get rid of those. Mm-hmm. Now, if she wants to, put them in the estate sale and sell them, that is perfectly fine. she wants to leave them in the will to her children or whatever, that's a different story. That would be gifting. If you give them away before we file Medicaid, we have to say, yeah, did you gift anything? So that's why I like estate sales.
Somebody said Medicaid seems very intrusive. Well, I can see how you could come to that conclusion, but Medicaid is a bureaucracy. They're in charge. They're entrusted with managing public funds to pay for a number of needs, not just old folks in the nursing home, but and they have rules that they expect everybody to comply with. So, yeah, you could say that they maybe overreach here or there, but I think that on the whole, they have some fairly black and white rules that we're all expected to understand and comply with. So I don't know if I would say they're intrusive as much as I might say that they're very detail oriented.
Thorough.
Yes.
Here's another question. This may be our last. If a child of a surviving spouse is named an executor and agreed upon by both siblings initially, and the executor doesn't honor the parents' verbal wishes and divide the estate equally, are there legal ramifications a sibling can file against the executor, other sibling, to gain an equal share of the parents' remaining assets?
Okay, so this is not really a Medicaid question. It's more of a probate question. And what it sounds like this person's asking is, if one of the siblings is appointed executor and doesn't comply with the terms of the will, do the beneficiaries have any recourse? And in this scenario, it says to honor the parents' verbal wishes. Well, a will specifies exactly what's supposed to happen in writing. It's signed by the testator, it's witnessed, and it's notarized. That is what's followed by the court. If a parent says after they do it says no will. No will means no, it's your word against somebody else's word. That's why having a will is so important. If you don't have a will, it's very easy to get into that he said, she said argument. Well, mom said I could have the lake house. Well, she didn't tell me that. Well, you're not going to get the lake house. That's just not the way the law works. So if it's important enough to you to tell somebody, it's important enough to put in writing in a will or a trust. Otherwise, your wishes aren't going to be carried out, honored.
And we'll end with that. So get a will plan early and remember to do your evaluation. It's at surveymmonkey.com/r/5 Y6W as in Tom, G as in girl, L as in Larry. And the password today is snapshot, and that has a capital S. Please remember that. Valinda, yes, they'd be happy to consult with you in Mobile. I'm sure they would work all over the state and then even in other states. So please, y'all, if you have clients who could benefit from working with Bill and Pam, or please do reach out to them. Up in the chat room earlier, you'll find their contact information, or you can just Google Bill Nolan Elder Care or Pam Strickland Medicaid, and you'll get them. They'll come up. That's what I did pretty quick. And that'll be it. The CEU code word is snapshot, one word, snapshot with a capital S. And I appreciate y'all for being here.
Yeah,
Thank you so much. Thank you, Bill and Pam. And those who are still listening, we'll probably see Bill and Pam fairly often. I'll have to talk them into how often, but we'll see them more often in the future. Thank you all. Have a great week. Great. And hopefully see us on Friday when we'll do caregiver resilience strategies. Yeah. So thank y'all so much and join us again.